Okay, all right. We'll go ahead and get started. You have the floor. All right.
Got it. Yep.
Okay.
Thank you, Madam Chair, committee members. I'm here this morning with HB 1283, and this bill, I'm not going to call a simple bill, but a straightforward bill. It's a housekeeping bill aimed at creating consistency in the Class A and Class B felony definitions of aggravated assault in the juvenile code. So currently, the Class B designated felony, the aggravated assault definition, aggravated assault involving an assault with a deadly weapon or with any object, device, or instrument which, when used offensively against a person, would be likely to result in serious bodily injury, but which did not result in serious bodily injury. And then where we have the issue is with the Class A designation is aggravated assault upon an individual or situation described in subsection D, H, or K of Code Section 16521, or assault with a deadly weapon or with any object, device, or instrument which, when used offensively against a person, actually does result in serious bodily injury. And here's where we have the problem. It's provided that such deadly weapon is not a firearm. So to have consistency between Class A and Class B, we're proposing, if you look at the bill on lines 12 and 13, just to strike through, provided that such deadly weapon is not a firearm, so that there's consistency with both definitions. And my understanding is that Department of Juvenile Justice and Council for Juvenile Court Judges did not oppose the bill. And I've also invited the Assistant DA for Juvenile Court in Southern District, Joseph McKinnon, who actually sent this issue to us to testify as well.
Okay. Briefly.
Yes, ma'am. Good morning. Many jurisdictions have come across this issue where you run into the issue of where if you hurt somebody with a stick, you're going to get 5 years because it's aggravated assault with bodily injury. But if you shoot somebody with a gun and you actually hit them, then it's not really a Class A because it doesn't fit the statute because it says provided such as not a firearm. And so then you run into what is it? So if it's not a Class A or a Class B, it must be a regular felony for which you can only get 30 days. And so we've been working around that by charging aggravated battery. But sometimes you don't have an aggravated battery when you have an aggravated assault like that. So we just want clarity and fixing what we thought the legislature intended. I think the Back the Badge Act is what mummicked this up. And so we just want to make it more clear that if it's without injury, it's Class B. If it's with injury, it's Class A.
Okay. All right. Members of the committee, any questions? Okay. Try it.
No.
Try it.
I'm there.
There you are.
Thank you, Madam Chair.
There you go.
You had referenced two that were not opposed. Who is that again?
Department of Juvenile Justice and the Council of Juvenile Court Judges.
Okay, and are they in favor? Because not opposed is not necessarily in favor. Are they in favor of the change? Or just not opposed?
The email I got late yesterday from Juvenile Court was that there's no opposition.
Okay, thank you.
Do you have a question?
I do.
All right.
Thank you for bringing this bill. I've practiced in juvenile court and I understand some of the confusion. I just want to clarify, aggravated assault with a firearm will still be able to be dealt with in juvenile court. The juvenile court isn't deprived of its jurisdiction under this change.
Right.
Okay.
We're not changing whether aggravated assault on a public safety officer with a firearm goes to Superior Court. That's the only thing that goes to Superior Court. Everything else remains in juvenile court unless it's transferred from juvenile court to a Superior Court.
Correct. After due process of
Right, and all the rigmarole that goes
of the
with that.
child. Okay.
Yes, ma'am.
Thank you.
Okay. All right. Any more questions? All right. Seeing none, what is the will of the committee? There's a motion to pass and several seconds. All those in favor of the passage of House Bill 1283 LC 481099, please raise your hand. Any opposed, like sign? It passes. Thank you.
Thank you so much. Thank you.
All right, Bill, as soon as we get your copies of your bill disseminated, we'll get started. See, if you want to get started, Chairman Hitchens.
Sure. I know nobody's had a chance to read it. I just got this yesterday, actually. And as many of you know, this has been a multi-year project for me. And last year it passed out of this committee with no dissenting votes. But as I was filling out my questionnaire for rules, I got a phone call from somebody who was watching the committee meeting. It was the assistant deputy commissioner for the Department of Human Resources. And she told me if the bill went forward that I was going to hurt a lot of people. What this refers to is child support, and it's child support for disabled children who go on to be adults and they lose child support when they reach the age of 18 or they graduate from school. And the way it was constructed last year, and I was completely unaware of it, Representative Prentice made light of it in the committee meeting, but she wasn't certain, that if you receive more of the amount than SSI allowed, Social Security insurance, disability insurance allowed, that you lost it, and not only did you lose it, but you had to pay back everything you'd received. So in doing some research around the country, we found that we were told we couldn't do it. But in doing research, we found that over 30 states had already done it. So what we have here this year is the model from Florida that was passed last year without a dissenting vote. And what they do to avoid it is the money goes into a trust fund instead of going directly to them, and the money can be utilized as needed. But what it really refers to is, and the way I got into this is I deal a lot at home with a group called the Navigators, which is parents and children with the children that have disabilities, primarily they're on the Down syndrome or on the autism spectrum. And they call themselves the Navigators because the system is so hard to get through if you're a novice. They help each other navigate the system, and it's a great organization. There are probably about 100 people in it. And they not only do that, they have sports for the children to make them seem normalized. But I had an individual, a lady come to me who I'd known since she was a little girl. I know her ex-husband too. And it's an old scenario, but it's much more serious when you have a child with a disability. They got divorced. They got married young. She didn't have any special skills. She didn't go to college, and she spent most of her time dealing with her son, who's on the autism spectrum. After they got divorced, I knew the husband's father too. He had a very successful business. And when they got divorced, about a year later, the father died and left the business to the son. He subsequently sold it for about $30 million. And now he refuses to help in any way with the child with autism. She has no workable skills. She's into real estate now, but she's just beginning. She told me the month before last she made $1,000. And he took the child off his hospitalization, which wouldn't cost him a cent more. And he goes to therapy twice a week. It was $50 when he had hospitalization. Now it's $500 each time. And what's in the bill is the nuts and bolts of how we go about it. But really the trust fund is the key to this. And I've been before the Child Support Commission twice this year, and they seem to be very, very good with it the last time around. And that's it, except for the nuts and bolts, and I'd be glad to get into that if people have questions.
Okay. All right. If you wouldn't mind, just because we haven't seen this bill before, if you
Sure.
just would kind of give us kind of an overview briefly as we kind of walk through the bill, that would be, I would appreciate that.
Well, one of the concerns I have, as I've read it, and Ms. Doty over there brought it to my attention too, is that as we talk about the child, which really isn't a child, he's an adult here. In Florida, they call it dependent adult child, and it's throughout this. I don't know how you can be an adult child. It may be something in their definitions in Florida, but I think I probably need to find a better term for that. I don't. But it talks about separation, divorce, and the age of majority, and then goes into definition about they're incapable of self-support as a result of a physical or mental incapacity that began before the person reached the age of majority. And then it goes into support. The court, in the exercise of sound discretion, may direct either or both parents to provide financial assistance to a dependent adult child who has attained the age of majority. Then it goes, this is on page 4, if you go down, it lists about how much support, which is pretty much the same way the judges go about it in regular divorce cases in children that hadn't reached the age of majority, and then their ability to pay financially. And I've got to say, this isn't just a boilerplate for one person. As this came out and people became aware that I was interested, I found out that the divorce rate amongst this group and probably similar groups is much higher than it is in our normal society. There's a lot of stress and strain when you have a child like that, and they go their separate ways, and it just doesn't seem right to me, and that's the reason I'm here, and that the non-custodial parent just walks away. And I brought it up in one of the hearings over at Child Support. What if the custodial parent just walks away? And what do we do then? The child becomes institutionalized. He has no loving care, really. I mean, and it's a miserable life. And then the state pays a fortune to take care of him the rest of his life. So, and typically it's the female. I mean, we all know that's how things work out, and it just seems so unfair to me. Then we move on to page 5, and it talks about Social Security insurance and termination avoidance. And you'll see in line 96, well, starting in 95, the court, in the exercise of sound discretion, may irrevocably assign the support to a special needs trust established pursuant to 42 U.S.C. section 1396 P D4A or 1396 P D4C, and for the benefit of the dependent adult child by the dependent adult child, his or her agent, under a durable power of attorney, the court, a parent or grandparent, a guardian or guardian advocate who's been delegated those rights in order to maintain the dependent adult child's means-based government benefits. And it says specifically in here that the judge will not do anything to that would terminate the SSI benefits that they receive or Medicaid. All these children receive SSI and Medicaid when they reach the age of majority or they're emancipated. And I think that's pretty much it. It goes into how to bring legal proceedings. Whoever the guardian is can bring about legal proceedings in court. And when they can do that, which they can do that at 17 and a half, or they can, in the case that I brought forward, they can go back now and retrospectively bring proceedings.
Okay, all right. You have a question. Yep, your mic should be good. Tap it, make sure I got the right
This
one.
isn't in my bailiwick, you
Okay,
know.
there you go.
I don't do these kinds of things. It's just something that caught my attention. I thought was very unfair and needed to be resolved. So.
Thank you, Madam Chair. My concern is you have older parents taking care of the same type of, as you call them, adult children, and their income is usually very limited as well. So what is the proposal for that? If you got a household of the parent themselves is on Social Security, and then you have a child that's getting limited Social Security that's disabled, and that custodial parent, a non-custodial parent is being on SSI pension with limited funds. How do you intend to address that?
I don't know how we can change that. I mean, it's the system, and it's just like child support with regard to a normal child support. Whoever has the means has to pay. If they don't have the means, they can't pay. So I don't.
So you're using the same grid.
Right.
Thank you, Madam
Okay.
Chair.
I mean,
All
I
right.
wish there was some way we could fix that, but
Yeah, 'cause
and I see it all the time with people.
If I may.
I may be a senior citizen myself.
But I can see that making the non-custodial parent homeless.
Well, that's dependent on the judge, and I think judges have to use discretion. That if there's no financial means, I don't believe he's going to require him to pay anything. That's just a matter of the system.
And in that instance, what happens?
It stays static. I mean, they probably can get welfare or food stamps, but you know, you can't get blood out of a turnip.
Thank you.
Thank you, Madam Chair. Just clarifying a question, then I'm going to follow up on the question of the representatives. So on lines 26 and 27, we're defining adult dependent child as in code section 19.6-15, and I'm assuming later in section 3 is where we actually add that definition. Is that correct?
That's correct.
So the definition is not there yet. We're going to add it and put it in the bill.
It has been used in case law. Yeah.
Yeah, that's what
Yeah,
I'm saying. That's
that's
what
what
we're
he
going to
said.
add it to that code
Right.
section, so it's
Yeah.
not in there yet. I just wanted to clarify that. And then the second thing is, to follow up on the question here, is that on lines 91, once the order has been determined and an amount has been set, I guess, based on the child and the parents, you can go back later and modify it if the child's ability to pay for support themselves. But is there an ability, if the parent's situation changes, to modify it as well? And that's, I see a hand being raised, but that was a question that I had.
Okay. All right.
Hi.
Okay. I think you should be. Yeah. Good.
So I, in addition to criminal defense, do family law, and usually where the two of them come together. But the child support can be modified every 2 years without a substantial change of circumstance. But if there is a substantial change of circumstance, one of the parents loses their income, they become disabled, there's some other reason that there needs to be a modification, they can always go back to court.
And on line 93, it does say if there shall be 92 shall be modified for either party if the judge, trier of fact judge, determines that in the exercise of sound discretion there's been a substantial change.
But the substantial change is in the child's ability, not the parents.
Yeah. So I guess if they were to get a job, but it's not, you still can go for a modification every 2 years, with or without the substantial change in circumstance.
And you all know some of these children do work. You know, there's a lot of them in the group that I deal with that work in coffee shops in Savannah or, you know, behind the scenes and auto dealers. And they work very hard with regard to monotonous jobs. They seem to love that. Things that other normal people don't want to do, they do very well. And I've been involved with some of the people that hire them, and in many cases they want more of them because they do the monotonous tasks that nobody else wants to do, and they do them well.
Mm-hmm.
So,
Yeah.
and
Yeah.
they pay them.
Yeah.
I did.
Okay.
Yes. Thank you for bringing this bill. I was kind of intrigued. I've never heard of one of these trust funds before, so I was looking it up, and I mean, it's a thing that's done in many states. And just from reading shortly, it appears it's really a safeguard for the adult child because it establishes a trust. If something were to happen to the custodial parent, whoever takes custody of that child, if they're listed as an additional trustee, would have access to those funds to take care of that child in perpetuity, because the reality is oftentimes these adult children, you know, they do have, unfortunately, they outlive their parents sometimes. And so then you're in a situation where at least there's a mechanism to fund. Perhaps the non-custodial parent's still living, but the custodial parent has passed. So there's an opportunity to provide support for that child for a lifetime. So rather than the child support being paid to the non-custodial parent, it being paid to the trust actually is a safeguard for the child. So this is a very intriguing area that I've never really delved in before. But
And I don't see it right off the top of my head, but there's also an area in here, and I don't know whether the judge shall or may require one or both of the parents to have life insurance. So that in eventuality, if they predecease the child, which happens most often, then they have money that goes into that trust fund to assist them with the rest of their life.
yes, sir. I believe that is Section 4. And so that those funds could
Yeah,
also
the
be
bottom
placed
of the page. Yep.
in that trust. Thank you very much.
Okay. All right. More questions?
Yes, thank
Okay.
you, Madam Chair.
All right. There you go.
2 questions. So if the this disabled child is able to work, and earn some money, which is usually not a lot.
No.
So are all three incomes factored in?
I would think so. You know, the judge has to get financial statements from all parties before he makes his decision. But as we noted, they're subject to change from time to time. They have that 2-year review. But I would think that would be counted. I don't know.
Okay. And in regards to the trust fund, who establishes the trust fund and who manages that trust fund? Who's
Well, I
going to
think-
administer it?
And I don't
And
know
where those
anything
funds
about,
to do that come from?
I have no,
See,
I
that's
don't know anything about trust funds. I'm not a lawyer, and
well, I mean, would that be usually there's paid for an administrator over a trust?
I would think,
It would be governed by the federal law that's referenced.
yeah.
Oh, okay.
I know
And I don't
federal.
see in the supplemental. I don't see the trust fund language.
The trust fund language, special needs trust, it's on line 96. To a special
Yeah.
needs trust established pursuant to 42 USC section 1396 PD4A.
Got it. Thank you.
So it would be, the trust fund would be governed by that. There is, Representative Wilkerson, you were correct in that the substantial change in the child's ability to provide support for him or herself. If it be the will of the committee, we could add, if the parent's ability to provide support, the parent or child.
That would make it easier for me to vote yes, yeah. Without, because 2 years is a long time to go if you lose your job.
So if there has been a substantial change in the parent or child's ability. So, all right, you're going to make that motion to add at line 93 a substantial change in, and we're going to add the words a child or parents. In the child's or such parents. I don't like that. In such parent or child.
Yeah, that's all
I
right.
think that's cleaner. In such parent or child. So we're just adding a parent or, yes. So that is the motion. Is there a second? Oh, I'm sorry. We have to have a motion to pass.
The other,
Okay, all right, you have a question.
I need to be on speaker for this, but, but as you read it, it looks out of place where it goes into provide support for himself or herself. But maybe not, but,
What line are you on?
line 93 where you were making the amendment.
Correct.
And, when you add parent in there, provide support for himself or herself. Yeah.
For the adult disabled child.
To provide support and just strike for himself or herself? Okay,
and I don't know if it's necessary, but we have 2 grammatical mistakes in here that need to be corrected too, that you'll see on your sheet on lines 81 and 97. There are 2 commas in there that don't need to be there, that change.
okay.
143 shall needs to be put in for must.
That's correct.
Yeah.
Do you want to include those in
Okay,
the motion? or
all
just-
right. Okay. So, give me that. Okay. Substantial change in such parents. Such parents or child's ability to provide support.
As provided by this paragraph.
Okay.
And again, as provided by this paragraph at the end.
As provided by this paragraph. Okay, all right. All right, so is there a motion to pass? Oh, okay, there's a move and several seconds. All those, before we get to that, there's going to be a motion to amend Stay with me, folks. There's 3 amendments that we're going to roll into one. On line 81, we're going to do away with the comma. Line 93 is going to read sound discretion, that there has been a substantial change in such parents' or child's ability to provide support as provided by this paragraph. At line 97, we're going to strike the comma. And at line 143, we're going to strike must and insert the word shall. That is the move. I will make that move. Is there a second? There's several seconds. All those in favor of the amendment as I have delineated, please raise your hand. Passes. All those in favor of passage of a do pass recommendation for House Bill 499 LC 570102S, please signify by raising your hand. All right, motion passes. Thank you.
Thank you. I appreciate you getting this on too.